I get a lot of search and seizure questions from police officers, and in my experience, the unique situations officers find themselves in can be complicated. This week, I want to focus on consent searches of residences. However, I want to discuss that topic as it relates to multiple parties in a home. For instance, if two parties are home and both have standing in the home and one consents to a search of common areas but the other does not, what is law enforcement allowed to do? So, this week's video topic is consensual searches involving multiple occupants. I'm Steve Serbalik and I'm a panel attorney with ASCOPS in Arizona. To give some insight on this topic, we will focus on two United States Supreme Court cases, Georgia versus Randolph, a 2006 case, and Fernandez versus California, a 2014 case. These two cases will help to clarify how multiple occupants and conflicting consent affect an officer's ability to perform a warrantless search of a home. In Georgia versus Randolph, a wife allowed law enforcement to search her marital residence for drugs. Her husband was also at the home and had refused to give consent. The officers decided to search the home on the wife's consent, and the husband was indicted for possession of cocaine. The charges were overturned, however. In this case, the U.S. Supreme Court held that a physically present co-occupant's stated refusal to permit entry renders warrantless entry and searches unreasonable and invalid. In Fernandez versus California, a bystander said that Fernandez had committed a robbery minutes before law enforcement arrived. Police saw Fernandez run into an apartment building. They heard screams coming from an apartment and knocked on the door. Roxanne answered, battered and bleeding. The officers removed Roxanne in preparation for a protective sweep. Fernandez came to the door and objected to the sweep. Officers arrested him for the assault against Roxanne. Later, Fernandez was identified as the perpetrator of the robbery. An officer returned to the apartment and obtained Roxanne's verbal and written permission to search the apartment. The officers found items linking Fernandez to the robbery. Fernandez wanted to suppress the items, as he had objected to police presence earlier. The U.S. Supreme Court held that police officers may search a home without a warrant if a physically present occupant consents to the search, and no physically present occupant refuses the search, even if a physically absent occupant would object to the search. So the takeaway is this: if multiple people have standing in a home, and one of those people present in the home objects to a search of the common areas, a police officer cannot perform a warrantless search based on that consent. But if a person with standing is absent from the residence and objects to the search, an officer may still search, provided that officer has consent from a physically present occupant. Now, keep in mind, arresting someone from the property after that person refuses consent with the intention of removing their refusal from the equation is not okay. If that person was on the property and refused consent, you're better off just getting a search warrant. If you have any questions or comments, please leave them in the comment section down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow and reach more officers. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.